To our compliance webinar today here on October 10th, 10/10 at 10 a.m. Pacific, and that was by design. We've got a lot of content about the new TCPA changes. There's been a lot of questions and confusion in the industry about what's going to happen, and I can't believe it's going to be next week, next Wednesday, October 16th, when a lot of the contact center world is going to be a little bit disrupted. We've seen numbers with some of our clients where the contacts per hour on calls, when it comes to not being able to use a dialer to call cell phones, going down from 10 to 15 to as little as 2 or 3. It's the primary means by which most people I know communicate these days. So it is going to have a big impact, and we're very fortunate today to have two of the leading experts, David Kaminski from Carlson & Messer and Christine Reilly with Loeb & Loeb, to really break down the issues for people. I know we've done a series of webinars leading up to October 16th, but this is, I think, our kind of final one before the rules hit. And this is all the information today is brought to you by our company, Contact Center Compliance, DNC.com, as well as Connect First, one of our partners leading the edge with some TCPA compliance solutions that they're going to be talking about later. What we're going to do is have about an hour, hour and a half to go through the material. We've got a lot of it, so time for questions is going to be fairly limited. If you've got questions about the slides and access to material following the webinar, we will actually be sending that out so that you can get it via slide format as well as recorded version, which should come through today. So with that being said, I'm going to turn it over to David so we can get things started. Thank you.
Thank you so much, Ryan. Really appreciate that introduction. Ladies and gentlemen, we do have a lot to cover today, and we know that you do have questions, and we may not have time to answer those questions, but hopefully they can be answered in the very near future after this conference. Hopefully most of your questions will be answered by the content of the discussion today, and with that we're going to move right on. So today, just briefly, we're going to talk about today's topics. We're going to give you a brief overview of the Telephone Consumer Protection Act. Most of you know it. There have been some changes there too. We're going to talk about the FCC changes to the TCPA regulations, which you know are draconian. We're going to talk about the key issue, which is what is written consent, how the new written consent requirements that start October 16, 2013 are going to occur, what's required, and what procedurally you have to do. And then we're going to have some questions that we have already built in that we're going to answer, and I think that we're going to give you a lot of content here. So moving right along to the TCPA overview. As you recall, the TCPA basically it restricts the use of automated technology to call cell phones. You all have been through this drill before. This has been prevalent in so many industries. It's not just affecting your telemarketing industry, as you know. It's affecting all industries across the board, and that's why all industries are literally pounding the FCC right now to make significant changes, on the dialer issue, to clarify what is a dialer, because these new laws are plaguing every industry, and it is not just the telemarketing industry that is being brought into the purview of the TCPA. Next slide, let's talk about where the TCPA applies very briefly. Residential phones. Again, if you initiate a pre-recorded message call to a residential line, that is a trigger for liability under the TCPA. Again, a pre-recorded message call to a residential phone line can trigger potential TCPA liability unless you have prior express consent. It's an emergency call, or there's an established business relationship. Again, you know the established business relationship exemption is going by the wayside as of October 16th. It will no longer exist. So that's the trigger for pre-recorded message calls to landlines. If you're making an informational call, pre-recorded message call to a residential line, you may have an exemption. The commercial call exemption under the TCPA may potentially exempt potential liability, but you've got to be very careful. But there is not the same exemption for telemarketing calls. Let's go to mobile phones. Slide 5. Again, when you're making a mobile phone call, if you're making a call to a cell phone via an automatic telephone dialing system, you need to have prior express consent to make that call. That's for general calls. We know now with the October 16th rules coming in, you need prior written consent. We're going to get into the details about that later. Remember that the exemptions that apply to calls to residential lines do not also apply to calls to cell phones via automated telephone dialing equipment. Let's go on to the next slide. What is an auto dialer? Most of you know it's this crazy draconian definition that says it's equipment that has the capacity to store or produce numbers to be called using the random and sequential number generator and to dial those numbers. Most of you don't have dialers that fall into this purview, but the FCC decided in its infinite wisdom to give an expansive interpretation of what is a dialer under the TCPA, and that's the problem. They're trying to bring within the fold predictive dialers generally, and of course that phrase that they use in the 2008 ruling, dialers that have the capacity to dial without human intervention. No one quite knows what that is, but the FCC themselves have admitted that they're confused too. They don't even know if that means your cell phone, because a cell phone can be programmed to dial without human intervention. So that's how broad and expansive the FCC's interpretation of the auto dialer rule has gone. And sometimes when you're looking at the auto dialer and you're looking at these brand new rules that the FCC has been coming out with, the key to potential compliance may be also the auto dialer side. So that's something to look at. Is there a solution that you have or a way that you can get around using, quote, an auto dialer that falls within the purview of either the TCPA itself, that strict definition of random and sequential telephone number generation, and then the FCC's expansive rules on using predictive dialers and dialers that have the capacity to dial without human intervention. Again, capacity to the FCC and the TCPA is very clear. Many of you know, and next slide 7, we've got the recent changes to the TCPA which have already come out. This is from the FCC's February 2012 ruling. This is in conjunction, of course, with the October 16th rules that are just about to take place. We've got the abandonment call rule and the opt-out requirement rule. On the abandonment recall rules, basically the new regulation, and I know many of you probably already have this in place by now, since it was supposed to be in place as of November 15th, 2012, that new rule basically states that for a permissible call abandonment rate, the safe harbor, you have to have a 3% abandonment rate max, and that is measured per campaign over 30 days. So that's very, very important. And remember, a call is generally abandoned if it's not answered within 2 seconds of the called party's greeting. That's also very important to know. Then with respect to the opt-out requirements, the new regulations basically require that if you have a live operator abandoned call, and the message must contain an automated interactive voice and some kind of key press activated opt-out mechanism that gives the called person who's being called the opportunity to make a do not call request prior to terminating the call. One more issue on the abandoned call messages and the opt-out issue. The new regulations also basically require that any live operator abandoned call message must contain an automated interactive voice and or key press activated opt-out mechanism that basically, again, enables that called party to make a do not call request prior to terminating the call. These are very important rules. Most of you have them in place, and of course the mothership of it all is the prior written express consent coming into play as of October 16th, 2013. You also, of course, have the EBR, the Established Business Relationship Exemption for calls to residential phone lines. That is going by the wayside. Remember that particular exemption never existed to cell phones. It was only an exemption for pre-recorded message calls to landlines. Christine?
Yes. Can we talk about the background of these new rules? Let's move to slide 8. Just talk a little bit about why are these new rules being enacted and sort of what is the background of what's happening here. And it really goes back to the telemarketing sales rule, which is a rule adopted by the FCC back in 1995. If you're subject to the telemarketing sales rule, you already know that you have to get prior written consent prior to sending pre-recorded telemarketing messages. So for some of you, these new requirements may not be that big of a deal. If you also have been subject to the TSR, you also probably know that unlike the TCPA, the TSR actually doesn't cover auto-dialed calls. The TCPA does. What the FCC had in mind here was to make the requirements for telemarketers uniform, or at least to maximize consistency across the different telemarketers. And the reason is that there is a difference in jurisdiction between the two agencies. Let's go to slide 9 to talk about what those jurisdictional differences are. The FTC has jurisdiction over many telemarketers, but it actually doesn't cover a number of entities. So the real difference here is that the FCC's jurisdiction covers all telemarketers. Regardless of industry, whatever you're located, it impacts across the board. Now the FTC, under the TSR, did not cover jurisdiction for common carriers, banks, credit unions, savings and loans companies, insurance companies, and airlines. So these are the types of companies that are most likely to be impacted by the new rules. If you're already complying with the TSR, this probably won't be that big of a deal, but if you're not, you're going to need to make some significant changes going forward. Let's move to slide 10. The Established Business Relationship Exemption. So as many of you probably know, the existing rule as of today is that consent's not needed to make a telemarketing call to a residential line if you have some type of established business relationship with the person that you're calling. And just to emphasize this, the Established Business Relationship Exemption only applied to residential calls. There is no such exception as it relates to mobile phones. But at the end of the day, it's not going to matter anymore anyway, because as of October 16th, there is going to be no established business relationship for any telemarketing calls, period. You will not be able to rely on any kind of relationship to make a telemarketing call. So just throw it all away, forget the established business relationship exemption. It doesn't exist as of October 16th.
And if I could just say something real quickly, group, that remember for non-telemarketing calls, to the extent you're making a non-telemarketing call, then if it's an informational or other call and you're making a call to a residential line, leaving a pre-recorded message, again, you may still have the benefit of the commercial call exemption set forth in the FCC regulations. But, of course, that's different for telemarketing. That commercial call exemption won't apply for telemarketing because it is a commercial call that does not include basically telemarketing or an unsolicited advertisement. Christine?
That's right. It's a good point, David. Moving on to slide 11. So here's where the new rules come into effect, and this is what's causing most of you a lot of heartache. If you're making a telemarketing call, and we will get into what is telemarketing in a second, if you're either doing pre-recorded or artificial voices to make phone calls, or you're doing auto-dialing, to make telemarketing calls. The prior rule was that you just needed some kind of prior express consent. And it could have been verbal, it could have been written. Starting October 16th, regardless of what type of phone you're calling, whether you're calling a residential line or you're calling a mobile line, you must, prior to making that call, have prior express written consent. So the key here is, starting October 16th, your consent must be in writing. And of course, there are, we will go through exactly what does that mean. What does written consent mean? Just a little side note here, there is also a prior written consent rule that's already in place, and that applies to making calls to numbers that are registered on the National Do Not Call Registry. So that doesn't change. We're really just making this all consistent by saying if you're making telemarketing calls to any kind of phone, you must have written consent moving forward. So I know a lot of you are probably wondering, and this issue comes up a lot, what is telemarketing? And we're on slide 12 now. And you can come up with a lot of creative arguments about why something is or is not telemarketing. But at the end of the day, if you are making a call and you're promoting a service, you're offering a service, you're asking people to purchase products or services, you are engaging in telemarketing. The definition of telemarketing by the FCC is considered to be very broad. So if you're inducing the purchase of goods or services, maybe on that call or even in the future, you are making a telemarketing call. I tell our clients that generally speaking, if your call is not purely informational in your message and your purpose, you are probably engaging in telemarketing.
And that's a very good point, Christine, because also with regard to these consumer rules, with regard to these telemarketing rules and the way the FCC is going to interpret them and the way the courts are going to interpret them, most courts throughout the country that we've seen so far, they're interpreting consumer protection statutes in a very, very broad manner. They're also interpreting FCC regulatory orders that are consumer favorable in a very, very broad manner. So unfortunately, you have to take a conservative approach to your interpretation of what is telemarketing. And that's what we basically tell our clients, because under this particular regulatory climate, we don't have a choice.
I think that's right, David. And I'm just going to give a really brief example because I know this question has been passed by me several times now. What if you have some kind of service and you're not charging consumers for your service? It's a free service, but you are marketing your service and putting it out there. And although you're not paid by consumers, you are paid maybe by a third party that's involved in the transaction. So let's say it's some kind of membership, and you're promoting a membership. It's a service to consumers. And you match them up with some kind of, could be anything, auto dealers, it could be doctors, it could be anything. And when consumers sign up, you get paid some kind of lead fee or lead generation fee for that consumer. I've been asked several times now, is that telemarketing? And I've said consistently, that will probably be deemed telemarketing. And I think you should consider complying with the new rules because telemarketing is considered to be very broad. And David, I don't know if you have thoughts on that, but I'd be interested in hearing your perspective as well.
Well, that's a very good point. You know, we're getting asked the question all the time. Look, I'm really not telling anyone to buy someone. I'm just getting a list of person's names, and I'm just uploading that and giving that to someone else. You know, again, lead generation. Lead generation isn't something that just, it sort of fell through the cracks, but most lead generation will be considered to be telemarketing. Anything that promotes, anything that attempts to sell, that attempts to, quote, promote to sell, or, you know, is construed as putting someone's name on a list that gets to a different company that maybe the person who promoted it could get a payback as a result thereof pursuant to a contractual agreement. Anything in that nature could be deemed telemarketing. selling. It's going to be interpreted very, very broadly. And that's what I'm telling my clients right now. Again, you have to take the least restrictive approach and comply with these rules, because if they do apply to you and you're not complying, the risks are, again, draconian. It's the TCPA.
That's right, David. And let's just give a few more examples of what is telemarketing on slide 13. The first point, be aware of the upsell. If you're making a call and you're providing information to a consumer, but you're also trying to get them to purchase, renew some type of subscription, you are engaging in telemarketing. So if you have any upsell in your call, you are engaging in some type of telemarketing. Another example that we see is confirmatory text messages. You are allowed, as you know, under the soundbite decision, to send a one-time confirmatory text in response to an opt-out request. Now the issue becomes, can you include some kind of link to your website or marketing in that? Well, the FCC was very clear. You cannot include any marketing in that confirmatory text message confirming the opt-out. There's actually a really good case on this. It's the Holtz versus Redbox case. And what Redbox did is they included a link to their website in their confirmatory text message. And the issue there was, well, does that constitute telemarketing? Because they did have, obviously, information on their website that would be considered marketing. And the court said, no, I'm not going to do what's called a look-through approach to liability. I'm going to say that this message itself doesn't contain any telemarketing or a marketing message, and it is not in violation of the soundbite decision. And I'll turn it over to David to talk about dual-purpose calls.
Sure. Thank you so much, Christine. So with dual-purpose calls, very interesting. The Ninth Circuit Court of Appeals, and remember, that's a Federal Circuit Court of Appeals, that decision has weight among the federal district courts that sit in that jurisdiction. And that decision by a Ninth Circuit Court of Appeals could resonate, of course, to courts throughout the country. Doesn't mean that they have to follow it necessarily, but they could, even if those courts are outside the Ninth Circuit jurisdiction. So that court said, we're going to look at some of these calls that Best Buy was making. There was a class action that was certified by the district court, and I'm sorry, it was reversed by the district court. They dismissed the class action, but then the Ninth Circuit Court of Appeals actually reinstated that and reversed that dismissal, saying this. There were several calls here. There were automated calls to residential phone lines. One talked to them about the Reward Zone program, and then they talked about, hey, your certificates are about to expire. They talked about the Reward Zone certificate about to expire. They said, look, go to this website. Thank you for shopping. Because part of the call was informational, but part of the call was also marketing, because they said, hey, thanks for shopping with us. This is going to expire, i.e. you're trying to promote people. Please renew. The court deemed that to be informational and telemarketing combined, but the telemarketing is going to outweigh the informational, especially in a call where you have informational and telemarketing. A court is likely going to require you to comply with the new telemarketing rules, so be very careful about having a dual purpose portion to your messages. If it's purely informational, you're good to go. But once you start directing consumers to renew their certificates, that's about buying, selling, directing them to a website, that's where you can get in potential trouble, and it becomes very problematic. And again, this Ninth Circuit. David? Sure.
What's interesting about that case, and a lot of heartache for many clients, there were multiple calls in that case, and one of the calls was what I would consider purely informational. It was, we're making some changes to our Reward Zone program, and go to the website to see those changes, something to that nature. And the Ninth Circuit didn't make any distinction between that call, which I would consider purely informational, and the other call which said, your Reward Zone certificates are about to expire, which does clearly show they're trying to get them into stores and to purchase stuff. So an ill-informed decision, in my opinion, but that is the law here in the Ninth Circuit on that.
That's a great point. That again, it was it was two separate issues. One was purely informational. The other one was telemarketing. Unfortunately, the court lumped them together as one and deemed it to be telemarketing. As you know, the Ninth Circuit goes on its own and comes out with some crazy decisions, but unfortunately, that's how broadly they interpreted telemarketing under this particular scenario. So let's talk about some changes, of course. On slide 14 to the TCPA, we've got the new written consent requirements, and we know that's plaguing the entire industry right now. And the telemarketing industry is in a flux because everyone says, how in the world do we comply with these? So again, these new regulations, they do apply to telemarketing. They do not apply to non-telemarketing information calls. If you are a creditor, if you are an airline giving an update, if you are a collection agency asking someone to make a payment on a debt, those are considered to be non-telemarketing calls. Again, with debt collection, the courts and the FCC doesn't know quite where to put them. They don't know if they're informational calls or what they are. They just know that they're not telemarketing calls. And for all of you out there that have seen one of the recent decisions that talked about the fact that debt collection calls don't fall into the purview of the TCPA and are exempted, that is a great decision for the collection industry, but it's one of those dangerous decisions also because it was not well grounded and doesn't have a solid basis in the law and is actually contrary to the plain language of the TCPA. So please don't construe that as a given and don't start failing to comply with the TCPA just because of that decision, because we believe that decision could potentially be reversed if it is taken up on appeal. So let's talk about what is non-telemarketing calls. You have the debt collection calls. We just talked about it. We have the creditor calling on its own behalf. We have calls by or on behalf tax-exempt nonprofit organizations. You have your credit unions. They're not going to be subject to the new telemarketing rules. They're not telemarketing. The political calls, your loan service calls, your refinance calls placed by loan servicers pursuant to the ARRA, which is the American Recovery and Investment Act. Clearly not telemarketing. You get, next slide, 16, you get your airline notifications, you get your fraud alerts by the bank, you get your school and university notifications, the school closing, the doctor's notification, research and survey, your package deliveries, wireless use notifications. Those, again, we're talking about non-telemarketing. When we get to residential lines, again, there's no consent required for an informational non-telemarketing call to a residential line. And again, if you're making a non-telemarketing call using your dialer to a residential line and you're not leaving a pre-recorded message, you can use your dialer all day to make that call. It's just when you leave your pre-recorded message, that's when certain rules get triggered. Again, call to a residential line via an auto dialer, you can do that all day without concern. Of course, you've got to be very careful about the DNC rules, and I wish we can get into that because that would be a half-an-hour discussion in and of itself, but we can't. But you've got to comply with your state and federal DNC rules. So again, with Christine, with regard to mobile phones, let's just talk. Can you talk a little bit about the consent in that area?
Yeah, this is a point that cannot be overstated enough. There is a real difference between residential phones and mobile phones. Unfortunately, for mobile phones, in the statute and the regulations, there are really only two exceptions to making calls. Either you have the prior express consent of the called party, or you're making an emergency call. So, you know, to sum it up on slide 18, if you're going to be calling mobile phones, even if you're engaging in non-telemarketing, you are going to need some type of consent. It's either going to be verbal or written. It's not required to be written if it's non-telemarketing. But regardless of calling a mobile phone, you must have some type of consent. And that applies, that's the rule now, and it applies after the 16th. So let's move on to slide 19, and let's really get into what is written consent. because I know most of you on the phone right now want to really know what does it mean and how do I apply it. Let's figure this out. Well, I have on slide 19, we have the provision. This is the actual provision from the regulation that covers mobile phones. And you'll notice, just like David said earlier, for mobile phones, you have two things you need to be aware of. It covers pre-recorded messages or artificial voices, and it covers your automatic telephone dialing system. So if you're using one of those, you are implicating the TCPA now. I know it doesn't say mobile phones or cellular phones in this particular provision that you're looking at, and the reason is that it has a reference to paragraphs A1I through 3. It's under that little 3 that has the cellular phone provision. So it doesn't say cellular phones, but trust me, it's in there. And of course it has, there's an exception for tax-exempt nonprofit organizations, those that are doing HIPAA, and that's included in there. But that is your provision that's now covering written consent for mobile phones. Let's move on to what the provision is for residential calls. Slide 20. So here we have in the regulations the new language about prior express written consent of the called party. Now it's going to look very familiar to you back in the earlier slides of our presentation where you have these exemptions. So you have I through, there's 5 different exemptions here. And I just want to point out something that, is an important difference that shouldn't be lost. If you're looking at the third one, it's made for a commercial purpose. Now, what it used to say is made for a commercial purpose but does not include or introduce an unsolicited advertisement or constitute a telephone solicitation. The FCC has now gone and changed that language to say introduce an advertisement, so the word unsolicited is now gone, and change telephone solicitation to now say telemarketing. We could talk a little bit more about that later, but advertisement and telemarketing are both defined under the regulations. And one of the problems here is that advertisement is defined very broadly. Not clear why they decided to take out the word unsolicited, but it's certainly a change that's been made and should take notice of that change. So here's your provision covering residential phones, and I'm going to have David talk to you about what the definition of prior express written consent is on slide 21.
Great, thanks, Christine. Okay, so on slide 21, let's talk about what is written consent. Again, it's going to be that agreement. It's going to be in writing, and they're very clear about that. I think there's no mistake about that. We've talked about the October 16th written express rules. It's got to be in writing. Of course, that writing word has some flexibility, and the FCC has given a flexibility in that regard, such as eSign. We'll talk about that in a minute. But you got the agreement in writing. It's got to have the signature of the person called, that they're clearly authorizing the seller to allow the delivery, cause to be delivered, advertisements, telemarketing messages, using, and you've got to actually tell them this. You've got to say that you're using an automatic telephone dialing system or an artificial or pre-recorded voice, the exact language out of the TCPA regarding the dialer and pre-recorded message law. This also consent is going to have to say that the telephone number which you are authoring, that you're authoring us to use, we are authorized it to use for advertisements or telemarketing messages to be delivered. And you're going to see that it has to be delivered to specific named entities. And that has to be very clear. And we're going to get into that in a minute. So let's go to slide 22. This is some additional requirements regarding this written agreement and all of the language that it contains. First of all, it's got to be clear and conspicuous. And Christine and I have been talking about this, and I know there's many questions. I saw a client of a samples written express consent requirement, and it was so buried I couldn't even see it. And that's a problem because it has to be clear and conspicuous. And clear and conspicuous has very precise and specific definition under Webster's dictionary, and that's exactly what the courts are going to go to when they're looking to determine whether your particular language at issue was clear and conspicuous. It has to have those disclosures, and it's got to inform them that by executing this agreement, that the person authorizes the seller to deliver or cause to be delivered telemarketing calls using that auto dialer. And that language has to be clear. You can't bury it. It's got to be up front and center. And you also have to tell the person they've got to be able to read in clear and conspicuous language that they're not required to sign this agreement or agree to enter any agreement as a condition of purchasing any goods or services from the company. So that's very, very important. These two issues have to be front, center, clear, can't be buried. Someone's got to be able to read them. They can't be hidden. Someone has to say, well, I never saw that, and it's got to be so that the reasonable person can see them, understand them, review them, and get them. Christine, any further comments on these issues here?
I think what you've said is spot on, David. And, I know this is a very difficult issue for many of you that are worried about having to go back, either get new consents from your existing customers or, get new consents going forward, and worrying about conversion rates of who signs up with either on your website or in some other means. And I know I've spoken to several clients about this issue and how, what does it mean to be clear and conspicuous? Well, if I can't see it on your creative and I don't notice it front and center, it's probably not clear and conspicuous. And you could play around with the location and the placement of where you put your disclosure, but at the end of the day, clear and conspicuous is now defined. In fact, let's go to slide 23. The FCC has defined for us what it means to be clear and conspicuous. It means apparent to the reasonable consumer and separate and distinguishable from the advertising copy or other disclosures. So if you're thinking about putting your disclosure at the bottom of your web page in 8-point font, that is not going to be sufficient. It needs to be seen by consumers. I know we don't like it. I know it's difficult, but that is the new law, and FCC has made it pretty clear. So, let's move on to another requirement here on 24. What is the specific seller requirement? This is another one of those that's a real tough one. The new regulations don't actually reference specific seller, but if you go back to the FCC's order where these new regulations were issued, it refers to a specific seller. And the reason why is it's borrowed from the FTC's telemarketing sales rule. So what does that mean to be a specific seller? Well, the FCC is contemplating a written agreement between a particular consumer and a particular seller. So, what does that mean? Do you have to name the seller? Do you have to name your telemarketer? Well, I think one thing is clear. You have to name and identify the seller. So if you're selling goods on behalf of ABC Company, you must list and name ABC Company. I often get the question, well, what if we have a calling center or we hire someone else to make our calls? Do we need to name them too? Well, if they're saying they're calling and they're saying we're calling on behalf of ABC Company and we're selling ABC Company goods, I think the answer is no. But if you want to be safe and you want to put in the name of the company actually calling, there's nothing wrong with that. I don't think it's required. But, and I've also talked a bit about someone who worked at the FCC about this, and they do agree that at the end of the day, what's important to name is who's the ultimate seller of the goods. That's who you need to be naming. Now, obviously, that's going to cause a lot of heartache for you if you're doing third-party lead generation or third-party marketing. How do you figure that out? Do you have to name them all? Do you have to do parents and subsidiaries? A very difficult issue. David, do you have some thoughts on that?
It is a difficult issue, and there is not exactly specific clarity right now. To the extent that you can name the affiliates, the marketing partners, because you know who they are, the better thing is to, quote, name them. You can name everybody down the line and down the chain. That's going to help. If There's going to be times that you can't, and we understand that. Parent subsidiaries, maybe, maybe not. It's sort of that's sort of a very, very gray area. And maybe that is going too far. I believe that is if there's a pretty fairly strict compliance with the rules and that you are naming the specific seller at issue or the sellers at issue, I believe that you have mostly covered the rules here and protected yourself. Clients are asking me all the time, do we have to name the affiliate? Do we have to name the marketing partner? Sometimes we don't know who all of them are. Sometimes we don't even know the specific and exact names of all of them. To the extent you know, name them. To the extent that you can't, if you're naming the specific seller, you should be covering yourself fairly well under the rule. Again, we're treading under some new water here. We don't know how far the FCC is going to go with this. When we talked to the FCC directly to get some clarity, I met with them back in April 2013, and to try to get some clarity on this issue, they didn't themselves know, but they did indicate that at least at a minimum, the seller has to be disclosed, even if, again, a third party is calling on behalf of the seller. It's the seller's name who should be up front and center.
I agree with that, David. We'll have to see exactly how far the FCC goes, and probably even before the FCC, how far the courts go, because realistically speaking, courts are going to start making decisions on these new rules before the FCC probably comes out with any further guidance. So let's move on to. I think we've probably already talked about this on slide 25. You have to say it's the condition of purchase requirement, saying that you must disclose that your consent is not required as a condition of purchase. Let's go and move on to signature, as I realize we don't have a lot more time in our presentation today. This is an important requirement. You need to have a signature. What does that mean? Well, if you have an actual physical paper or an application, you must have the consumer do a handwritten signature.
I agree.
A lot of you. Oh, go ahead, David.
No, I agree 100%. If you have a written document, get a physical signature.
Yes, and for many of you, you may not be using written forms or hard copy documents, and you're doing a lot of your work online. Well, the good news here is the FCC is going to allow compliance with the eSign Act to satisfy the new rules, and this is really good. I mean, you can get consent through email, website forms, text messages, telephone key press, and voice recordings, all under the eSign Act. So let's say you're on a web form. You can have all of your written consent disclosures there. You can have a consumer manually check a box, making sure that they consent, and you can have them click a button to proceed with the transaction. Now, do you need both? Do you need a manual checkbox and a click button? Probably not. If you can do it, great. It's an extra layer there. One thing I will tell you, this graphic here shows a partially checked box. Do not pre-check your boxes. You do not want to have the consumer already have pre-checked it and not have looked at it. So please avoid pre-checking your boxes. If you're going to have a pre-checked box, make sure they manually have to check it themselves.
That's right. That's a great point, Christine, and I know that some companies have informed me, well, sometimes that their check boxes, they automatically populate when the, let's say, consumer gets into that area of the web page or is in that area and the mouse is in that area, it automatically populates. Block that automatic population of that checkbox. That's a great danger. So if we can give you one thing to take away, it's that today. To make sure that it can't be automatically populated, because then you're going to get into a legal battle, a crazy legal battle, that the consumer is going to fight. I never did check this. I didn't physically click on the mouse and do it. We're going to argue that, well, you did because you were in that area, but if they determine, they get discovery that shows that by merely scrolling over it with the mouse automatically populates it. Big, big problem. And in talking about these written consent requirements, this was, quote, the FCC's gift to the entire telemarketing industry, and I know I say that with tongue-in-cheek, of course. The gift was, well, we know you can't get physical signatures, so at least we're going to let you get this by the eSign Act. Christine and I completely know that even the eSign Act to get consent is draconian in and of itself. We know that to get it on a voice recording. In fact, I just was on a call with a bank recently, and they were calling me and they asked if it was my cell phone, and I confirmed. And then the person started reading all the disclosures, which were clearly disclosures to try to capture, of course, the telemarketing express consent under the new rules. And these disclosures were so long, it went on and on and on. I was ready to hang up. And of course, when the person said, do we have your authority to do so? And if so, I'm going to press this button so you can confirm. And they were going to allow me to leave a live voice recording. I said, please don't bother, no. That's just to show you that it's just very difficult to capture consent, even under eSign. Yes, it works very well with a website. Sometimes email can work very well. Text message has its issues. We'll get into that in a second. Telephone key press could work, but the voice recording or the live explanation, you're going to lose people. They're going to drop off the call. They're never going to wait for all that explanation, and they're not going to wade through all this information. So it's very difficult. We understand that, but these are the new rules. Christine, any comments in that regard?
No, I'm completely on board with everything you said, David. And let's get into some of those issues right now. Slide 27. How do I obtain written consent? You obviously have some traditional paper forms. You'll need to do new forms. The FCC expects that if you have applications, purchase orders, reply cards, they're expecting you to have issued new cards, new applications. And that's why they gave you over a year to do that, and specifically in the order. We've talked a bit about websites. That is probably one of the easier ways of getting consent, to have your disclosures on a website, have your I consent or I agree button, and get your eSign signature that way. If you have to log in or sign up, that's a great opportunity to get your written consent. So for example, for your existing customer base, if they have a login every time they need to use a system or a membership, have it on the next login. Have all those requirements. Get them to consent that way. On slide 28, we talk about the other ways under eSign: telephone, text messaging, email. One thing I do want to note, and this may help, if you want to do eSign Act and you want to get them to sign up and get the written consent, you can do it through a text message. You can do it through an email. My advice would be redirect that consumer to your own company-controlled website if you can. It's going to be very difficult to get all those disclosures just through text messages. So my suggestion, say that you want to get their consent, especially for existing customers. Direct them to your own website where you know you have the consent and you have them done properly, and have them opt in that way. That works Christine, both for text message and email.
That's absolutely right, Christine. That's a great point, because if you are trying to leave a text message with all of the disclosures, you're going to lose people, and that's the whole point. Can you do it? You probably can, but you're going to lose people. They're never going to read it in a text message. People don't have that capacity. Also, you're not going to be able to fit it all in one probably text message because of the limitation on the characters. It's going to have to go into a second text message. You've already lost the consumer at that point. But if you redirect them with some kind of link, something that they have to click on, which opens to a website, which gives the full explanation, that you're much better able to, quote, give them all the disclosures they need, comply with eSign Act, and have the person actually sign up for something, take the time and read it, or just maybe they may click it because they're interested, but they can read it. It's not on a text message. It's called overload, and statistics have shown that you overload someone in a text message, they're lost, they're gone. It's never going to work.
David and Christine, we actually had a question come in that is really related to the website submission of consent, and the question was about offering some advice about the language on the button, whether it could be submit, go, next, etc. What would you guys recommend as far as, once they fill out their consent, maybe what that button or that actual eSign handshake might need to look like?
I love the buttons that I see. I consent. I agree. I mean, you could not be any more clear with a button like that. I do think if you have just the disclosures and you have submit, done, or whatever your button says is probably fine too. And in fact, it is fine too. But I agree and I consent because, God, it could not be any more clear that way.
That's right. Some people are putting a check mark with the word next. I like the words better. I agree. I confirm. Even if you have to use the words done, but the words I agree, they're simple, it's clear, it's unambiguous, it's unequivocal. And just clicking a box that says next, well, boy, I clicked the box next, but I didn't agree to anything. It didn't ask me to. So I think you got to be very careful with it in what you use, and probably I agree is the simplest and cleanest.
I agree with that. What we've done is giving you an example of written consent where all of these requirements that we've been talking about sort of come full circle on slide 29. This is just one example of how you might go about doing consent. It has a manual checkbox. One part that was added in here, I verify this is my mobile number. Do you need that? No, it's not required under the new regulation. But I like that because I want my consumer to be verifying that they've given me the correct phone number. And it certainly could help that they are verifying that and agreeing to that. And the reason being, as you probably know, unfortunately under the TCPA, misdirected calls can also implicate TCPA liability. Even if it's not intentional, completely inadvertent, still can implicate the TCPA.
And that's the danger. I see that we're running out of time here. That basically concludes the general presentation. We know that you have so many questions probably still remaining. We actually gave you a summary in the PowerPoint. We actually gave you a written consent checklist so you can look to make sure that's on slide 33. And then we have just a written consent step-by-step analysis that follows. We have some questions and answers that we already built in so you could read them to see, and that may answer many of the questions that you have. And that hopefully will help you. We thank you so much for listening today, but we have some more important words we'd like to introduce very quickly. Jeff Mina, who is the CEO and co-founder of Connect First, who wants to talk to you about something very important, because I touched upon the issue earlier just about some people tell me I can't comply. It's impossible for me to comply. I'm going to lose business. I'm going to go out of business. What can I do? Well, the only other alternative, if you literally can't comply with these rules, that you're faced with complying, that you must comply as a matter of law, then you have to look basically at a dialer solution. And so at least Jeff Mina can at least seek to address some of those issues.
Hello,
Jeff?
everybody. How's it going? Thanks, David. Thanks, Christine. Ryan, if you could go to slide 52 for me, that'd be great.
Thanks, Dan. Go ahead.
So Connect First was founded in 2004 because we saw a need in the marketplace for better contact center software. We've been providing our solutions to the industry for almost a decade now. And extending our standard offering into our new compliance suite was a pretty natural move. We're constantly striving to help our customers operate in an efficient and legal manner. And the new SAFE tools are helping our oldest and some of our newest customers stay in business through these tough times. So we have basically built a new product that we're calling SAFE. There's certainly no silver bullet here, but our goal has been to completely remove the possibility that our technology could ever be considered an automated telephone dialing system. It's no more an ATDS than the recent calls history on your iPhone or Android device. You know, we're hopeful that the FCC doesn't declare an iPhone an ATDS, because it'd be pretty painful to start writing letters to everybody that I call on a daily basis. So regardless of whether you're making telemarketing calls or not, the TCPA safe version of our platform eliminates a lot of things that a typical predictive dialer does. It can't predict an agent's ability or availability to take a call. It can't dial without human intervention. It only dials a 1-to-1 ratio. We don't anticipate the end of a call and take any actions, and we certainly don't store or produce telephone numbers to be called using a random or sequential generator. Next slide, please. So regardless of whether you're using the safe version of our platform or a standard outbound offering, we have a pretty rich set of compliance tools, and this is where our partnership with DNC.com comes into play. If you have an FTC org ID, you load it into our platform. You can scrub the national, state, and cellular restricted numbers out of your list before they even make it into your outbound campaigns. We've got a nice set of tools for managing your express prior written consent records to ensure that those don't get taken out of any list you load up. We also have a lot of tools, depending on how careful you want to be, how often you want to rescrub your data, from nightly to 15 days to 30 days, depending on who you're calling, how you're calling them. So there's just a lot of features built into our software to help everybody move forward through and past October 16th. Next slide, please. So we've got a lot of really good information on our website. We have the TCPA guide for contact centers that was published by DMG Consulting. They're one of the prominent consulting firms in the call center space. We also have some past webinars with David and Ryan available for download. Great information there. And if you have any additional questions, feel free to email us at tcpa@connectfirst.com, and we will try to get any questions you have answered. You know, we have access to David, and we can work with him and hopefully help clarify any questions that are still outstanding after this webinar.
Thanks, Jeff.
Thank you so much, Jeff.
I
Thanks, Ryan.
I just wanted to say a few words just to kind of wrap things up, and really appreciate David and Christine spending a lot of time on putting these slides and the examples together. We'll get the deck out to people probably this afternoon by tomorrow that you can open up in a PDF kind of mode and go back through some of the slides we didn't have enough time to cover. I do want to mention that one of the things that has come out of all this TCPA confusion is there's a lot of questions. There's a lot of questions about especially what other companies in your field are doing. One of the ways to kind of share some of that information and have a little more interaction is at our compliance summit down in Miami on November 14th. So got the link on the event that'll be going out as well. You can always just go over to dnc.com, over to events. And we also have a ability to do a test for anybody that's on the webinar if they're concerned. Obviously, the deadline is next week, but a lot of people still don't have a fully protected, third-party verified TCPA compliant scrubbing solution to separate their cell phones out so that they can work with Connect First or however they're going to try to fit into the mold of something that's not an ATDS. So if anybody needs to kind of get an idea of what kind of exposure they've got, we can definitely run data against both the ported New Star list as well as the carrier-owned data in order to pull that together. So that'd be definitely something we can help people out with. But I know there's lots of questions. I wish we had more time to kind of go through everything. Christine or David, you gonna have anything to add towards the end here? I know you probably could talk for hours about the TCPA and all the different cases and everything going on right now.
Well, I think we gave you a mouthful, and I thank everybody for their patience in listening to us, and thank you so much for attending, and good luck. We know, Christine and I know it's a lot to wade through, and just stay the course and, you know, comply with the law, and hopefully it's going to all work out. We're going to see how this is all going to pan out in the next several months.
That's right, David. It's going to be very interesting to see what happens after October 16th. One point I do want to emphasize is, these new rules do apply to your existing customers if you're doing telemarketing. So it doesn't just customers going forward. It does apply to existing customers. So I would encourage you to look at the slides under the frequently asked questions and the application sections on the presentation that specifically address those concerns. And of course, if you have questions, you can reach out to David and I directly. But you still have some time before the 16th. And thank you all for your participation today.
Thank you all very much. And that's a great point, Christine, because the new rules do apply to existing customers, and even if you have already written consent without all of the disclosures that are required, please look at the slides to see that how you can get both the rest of the consent that you need in order to comply under the law. Very critical. Thank you all.
Thanks again. Look for those slides, like I said, this afternoon, tomorrow. Hopefully we'll see some of you guys in Miami in November, and we'll definitely be putting on a couple webinars kind of post October 16th to talk about the impacts, what's going on. Obviously, most of the FTC and FCC is closed right now, so now would be a good time to make some contacts, try to get that consent. I'll leave it at that.
Thank you.
Thank you.
Thanks.
Bye.
Bye-bye.